Hello and welcome to a TWAIL symposium by RSIL. Today we have the pleasure of being joined by Professor Sumudu Atapattu. Sumudu Atapattu is a teaching professor and director of the Global Legal Studies Center at UW Law School. She is also the executive director of the Human Rights Program at UW-Madison. She teaches in the areas of international environmental law and climate change law and human rights. A prolific writer, her books include UN Human Rights Institutions and the Environment, Synergies, Challenges, and Trajectories, Cambridge Handbook of Environmental Justice and Sustainable Development from 2021, Human Rights Approaches to Climate Change, Challenges and Opportunities, International Environmental Law and the Global South, and Emerging Principles of International Environmental Law. Dr. Atapattu has worked on several projects as an independent consultant and attended several climate conference of the party meetings. She's also been present at UN expert consultations and taught courses on the link between human rights and the environment, especially climate change, climate migration, and small island developing states. Thank you so much for being with us today.
Thank you so much for inviting me.
So today we'll be talking about third world approaches to international law and how that relates to the environment, specifically international environmental law, climate change law, and the link between climate change and human rights. So I'd like to jump in with our questions. I read some of your articles and I found them very interesting. One piece that I really enjoyed was your book chapter on the significance of the international environmental law principles in reinforcing this North-South divide. So in that chapter, you highlight Nicholson's suggestion that as a discipline, international environmental law has failed to respond to third world concerns in a meaningful fashion. So I really wanted to hear from you. Do you agree with this assertion?
Yeah, and actually that's the very reason why we did the book International Environmental Law from the Global South. Because if you look at the main textbooks on international environmental law, many of them don't grapple with the concerns of the South. I mean, they do pay lip service. Obviously, some books are better than others, but we really felt that the voices of the Global South were not really reflected, as well as the concerns of the Global South, which are different. They are not reflected in these books. They are written by scholars based in the global north. They mean really well. I'm not saying that this was done deliberately, but they're not familiar with what's going on in the global south. And also, in order to understand where we are today in relation to international environmental law, we need to look at the historical developments dating back to colonialism and all the institutions and the laws that have evolved through those experiences. So that's why we did that book, to get to see to what extent these North-South disparities have influenced the development of international environmental law. So yeah, very much so.
And I'd like to hear a little bit more about the historic of international environmental law. Can you highlight a couple of areas where you've noticed that this disparity or divide in perspectives is most pronounced?
Absolutely. I mean, whole international economic law, trade law, investment law, they are all based on this disparity in the sense that, and they favor the global north. If you look at the voting in the World Bank or these international financial institutions, the global north dominates, right? G7 is all global north. They set the agenda, they set the terms. If you look at investment law, that's another area where the global south is marginalized. A good example is where under bilateral investment treaties, multinational corporations, which are not international persons per se, as you know, can sue sovereign nations and this has happened many times, giving multinational corporations the right to sue sovereign nations, I think is a huge problem. It's lopsided, and the bargaining power is very, very different, right? The global South wants investment. So they are ready to accept any terms in order to attract investment. So, they are ready to even accept being sued by multinational companies in order to get that investment. And international trade law is another area where, the global South concerns are not really taken into account. They have had to do so many adjustments to their policies in order to appease the World Trade Organization. So that's another area where you see these lopsided sort of policies and institutions that do not take the concerns of the global South into consideration.
Mm-hmm. And I think often the response to that is that within international environmental law, we have progressive principles that are said to protect the third world. Especially you have equity principles, but specifically common but differentiated responsibility.
Yeah.
And that's always pulled out as this kind of response to highlighting these disparities. And yet a lot of these other areas where there is disparity are ignored just because the common but differentiated responsibilities principle exists. So do you think that can it, I mean, while of course it does help, but it doesn't undo all of the disparities in other areas of international law?
No, it doesn't, because as you know, international law, as with any areas of law, domestic included, is very siloed, right? So International Trade Organization will not apply international environmental law. So because of this siloed approach, whatever gains we have made in international environmental law with regard to some of these principles that you mentioned, equity, justice, the common but differentiated responsibility principle, they are not applied by other branches of international law. There are some important developments that have taken place, like human rights organizations have started looking at these environmental principles and they are applying them in their judgments. So, for example, in Saatchi versus Argentina, decided by the Committee on the Rights of the Child, specifically applied the common but differentiated responsibility principle in their judgment. So there are some interesting developments taking place, but they're taking place very slowly. And I don't know to what extent the financial institutions where the power is really concentrated, I don't know to what extent they will sort of take account of these developments. And even within, let's say, the climate negotiations, the common but differentiated responsibility principle has been really controversial. So the Global South has tried to use it in relation to the loss and damage mechanism and in relation to adaptation for finance. And the Global North has always resisted these sort of developments. So although the principle has been adopted and applied in relation to climate change, it forms the very sort of foundation of the climate regime, climate obligations. It's still being resisted.
Mm-hmm. And I think there's a very similar analogy we can draw between common but differentiated responsibilities being there as a principle and then the application of it to the situation of the loss and damage fund. So while there was a decision to establish the fund, the operational aspects of that, where that money is from, how much money, where it's going, all of those things still we have issues in implementing those. And I guess we'll see that this year at COP28. So are there any particular areas where you feel like there'll be North-South tensions at the Conference of the Parties this year?
Yeah, I think the big issue is going to be operationalizing the loss and damage mechanism. One of the things that's going to be really interesting is who is required to pay into this fund, because right now it's all voluntary, right? So sort of a broad North-South division might exclude some of the major contributors to climate change right now, like China and India. So are they required, because China is the biggest contributor to greenhouse gases and India is now number 3, I think. So are we looking at how are we basing the obligation to contribute? Is it historic responsibility, which means that it will be the global north? So the US is the biggest contributor historically, but it's not the biggest contributor right now. So are we looking at current contributions, historic contributions? How are we going to sort of apportion responsibility to contribute to the fund? And then the second question is, who is eligible to and damage would be covered, and on what terms? So there are lots of questions to be answered, and I don't think a broad North-South division is going to help us with that. So I think we'll have to be more nuanced in our application when it comes to the loss and damage mechanism, because the major emitters today are not those who are responsible historically. So that's something that the international community will have to address. And as you can imagine, that's going to be very, very controversial.
Mm-hmm. And I agree that this.
And then,
please.
No, I just wanted to add that with regard to finance, because the global community pledged $120 billion per year, which hasn't come. There should be adaptation measures, help for adaptation measures. Maybe under the adaptation fund, some might come under the loss and damage. So all these require adjusting some of these lenses we are looking through in relation to climate change, because the dynamics are changing quite a bit, as you know. These major emitters, and even Indonesia, because if you factor in deforestation, Indonesia becomes number 3 in the world. So there are lots of complex issues to look at. And I don't think this broad North-South lens is going to help us too much, because there are sort of dynamics within these broad categories that we need to take into account.
And so on that bit on taxonomy, I agree that so many developments have taken place in the past few decades that North-South doesn't quite cover it yet. But are we in the process of finding a new categorization of these states? Is that based on their negotiating blocks? What's the progress been on kind of allocating which states have which interests and what they're advocating for at the Conference of the Parties?
So there are lots of different negotiating blocks. The small island states have always negotiated under actually 2 blocks. the Alliance of Small Island States, as well as SIDS, Small Island Developing States. Then you have basic countries, which are the major emitters. You have BRICS. You have EU as an alliance. Sometimes the US joins EU, sometimes they're at loggerheads. So depending on, and then you have the most vulnerable nations alliance, and lots of different sort of negotiating sort of blocs are there. So you have a mix of global north, global south, and then sometimes these alliances are helped by NGOs or scholars based in the global north, like Alliance of Small Island States has always had scholars based in the global north helping them. And I know there were scholars based in the global north who helped with the Vanuatu request for an advisory opinion. So these alliances have been happening as well across these different lines as well. So it's really hard to say whether new alliances will emerge. I think they will emerge, but what they are and what they will look like is hard to say, because they will negotiate along their common interests. And of course, G77 has been a big group, and China has always joined G77 as a bloc. You have the G20, and all these different groupings are available and are already there. And their interests are very different too, right? G20's interests are very different from the Alliance of Small Island States. So it's hard to tell what the new groupings will become, and also I think you have then the indigenous groups lobbying, you have the women's groups lobbying, and youth groups are a big element now, an important element. So you have these official groupings as well as unofficial ones that negotiate at these, or at least try to influence the negotiations at COP meetings. Yeah.
So given that the world is a lot more complex than it was when the third world approaches to international law movement started, do you think there's still value in using a TWAIL approach to the environment? And from your perspective, what does a TWAIL approach to international environmental law look like, and what does it mean?
So I think it's still important, because it really tries to put the focus on the needs of developing countries, and not just developing countries, but those groups that are vulnerable within developing countries, like indigenous groups and marginalized groups who really don't have a voice. So TWAIL tries to capture those voices at the international level, because international law, although there have been many developments, it's still very state-centric. So bringing these additional voices, and when I say state-centric, it's more global north state-centric, right? So the capturing the experience and the voices of the global south, especially those who are marginalized in the global south, is very important. So I think TWAIL still has an important role to play, but I think it also needs to take these nuances into consideration. So developing countries, when you say, is a very broad category, right? Is China a developing country? Is India a developing country? So there are lots of nuances that you need to take into account. So TWAIL needs to sort of move with the times to sort of see where where their influence is most important and necessary. So I think it's still necessary to bring those voices, bring those experiences to the international level, influence negotiations by highlighting the necessities and the needs of the global south at these international negotiations, but at the same time moving away from this broad developing and developed dichotomy, because there are communities within our own countries, within the global south, that are more affluent than those who are living in the global north, right? So there is a north in the south as well as a south in the north. There are so many poor people in the US, for example, who are living below the poverty line, who are awaiting relocation because of climate change. So you cannot sort of treat them in the same way that you treat the global north. So I think we need to be more cognizant of these different nuances within these broad categories that we have identified.
Mm-hmm. And I really like the idea of using climate justice as a principle or a structure, not just on the international level between states, but also within a state itself, and also between and within communities. But I wanted to ask you a little bit more about how the Global South interacts with the development of international environmental law. So of course, a lot of things have changed over the years, but still scholars from the Global South find it hard to contribute to that development because a lot of the power structures are within the Global North, or they require a certain level of accreditation from the Global North in order to just enter the field. So I want to ask you, what are the most important sites of praxis? And over there, what are Global South academics, practitioners doing to influence this development of international environmental law?
Yeah, that's that's a harder thing to sort of dismantle. If you look at the negotiations, for example, they are still dominated by the Global North. But in terms of sort of breaking these barriers, I think education is the key. So publishing about the Global South, the book that we did, I think is important. So we need more scholars to do publications similar to that, use them in their teachings, because there's no point in publishing something if it is not really used in our teaching. So I try to sort of assign chapters from that book when I teach international environmental law, because they try to highlight the experience of the global South, at least get the students thinking about these distinctions, because when you teach international law, they don't really know that there are these different sort of structures and different approaches to international law. So it's really important for excuse me, scholars and teachers based in the global north to highlight those distinctions and get the students thinking about these differences in their classrooms. In the same way, the scholars and teachers in the global south should collaborate with those who are based in the global north and try to get their sort of writings published in global north, journals, collaborations, etc. And also try to do your own journals. There is a Asian Journal of International Law. So there's no one silver bullet that you can adopt. So there are lots of things that can be done. So One of the projects that I'm involved in, which I started actually, is doing an edited volume on international environmental law and sustainable development in South Asia. Because we feel that there's so much rich jurisprudence that nobody knows about except us. And there are so many lessons that other regions can learn from South Asia. So, but there's no textbook or there's no book that looks at these developments consistently. So we decided to do it, and we really wanted to use scholars based in South Asia to write these chapters. So things like that can help as well. So I think education and publications and collaborations are the key to sort of dismantling these existing structures, and also getting the students based in the global north to recognize these nuances and distinctions that exist in the international structure. And at the same time, getting our students in the global south to appreciate that not everything that comes from the West is the best, because we have a tendency to think that, oh, we need to use these British books or American books in order to learn about these things. That's not the case. There's so much rich jurisprudence from our own countries that we should be thinking about, we should be using, and highlighting in, at conferences and things like that. So I think all those things across the board, it's going to take time, there's no doubt about it, but we have to do that.
And what you said really stood out to me, because that's something that we work on as well. We've noticed that with relation to Pakistan and international law, there's a lot going on, because Pakistan's at the intersection of so many different important issues, but there's not really much written about it, or it's not being talked about on an international scale. So I definitely think there's a call to action there for all law students and practitioners and academics, both in the South and the North.
Yeah, absolutely.
So thank you so much for joining us during this seminar. It was such a pleasure to pick your brain on all of these issues.
Thank you so much for having me.